Welcome to Property Power Talks, the exclusive podcast for NB Property Law. I'm your host, Kayleigh Swift, and each episode will dive into cutting-edge insights on property law, probate, estate planning strategies, and seamless estate administration. Whether you're a property investor, homeowner, industry professional, planning your estate, or wanting to understand how estate administrations work, then our expert discussions will empower you with the knowledge you need to navigate the complexities of property and estate planning law with confidence. Let's unlock the power of property and estate planning law together. Thank you very much for joining us today. I'm going to take you through some strategies for success in terms of today's market regarding retail and commercial leasing. So in terms of our agenda, as listed on here, there's a few of the things that we're going to go through. So basically, I'll take you through what the steps involved in actually entering into a retail or commercial lease, how to actually negotiate such a lease, what are the key terms and conditions to be aware of when negotiating these sorts of leases, what happens if lease premises become damaged during the term of the lease, what does it mean to actually have a lease registered and why would it be advisable to do so? And what type of lease incentives are available for lessees in terms of retail and commercial leasing. So essentially, NB Property Law, we like to think that we provide a very personalised, proactive solutions to our clients. We make sure that we're taking away the risk involved in transactions such as commercial and retail leasing and take the stress out of everything that comes with types of matters like this. So we don't just do property transactions, we also undertake estate planning matters for clients. So a lot of them own, several different properties, and we need to ensure that those assets are actually protected. And by way of doing that, we'll do up their estate planning documents as well. So we've got a team of legal experts here. Essentially, we're dedicated problem solvers committed to actually finding personalised solutions to fit our clients and help them find a way forward. We do also residential property transactions, so whether it be mum and dad conveyancing, we're here to provide the clarity and guidance needed for our client to help them find a way forward with their property or estate planning transactions. So what are the actual steps involved in entering into a retail commercial lease? So the first thing will be actually reviewing and assisting you with negotiating the agreement for lease. So the agreement for lease is essentially the core terms that make up the lease document. So those things we're talking about as core terms will be things such as the term of the lease, what rent we're paying, special conditions in terms of incentives, what type of guarantees are being required. So in terms of deposits that need to be put forward, sometimes personal guarantees if it's a company entering into the lease as the lessee. The next stage of the process will be undertaking appropriate legal searches for the property, the tenant and the landlord. So we want to make sure that we've done a title search of the actual land that the property is located on. We've done, if the landlord and tenant are companies, we've done ASIC searches to make sure that we're getting the right signatories on that lease. Then we'll actually have an actual draft lease document, which we will review for you. So that draft lease is going to be essentially based off the agreement for lease that's been signed, but in a much more extensive version. So, the retail and commercial leases, they're not standard leases. Sometimes there's an REOQ document that may be used for a commercial lease. It cannot be used for retail leases in Queensland, and it can only be used for leases that are less than 3 years. And they're a bit more standard, but they still come with a lot of special conditions. So we'll review that one. The next stage in the process is whether it is actually determining whether the lease is actually a retail lease or commercial lease, because if it is a retail lease, there's a lot more regulations about what can and cannot be done, and there's a whole piece of legislation around that. Once we've all reviewed the lease and we've made any amendments we need to, all parties are happy with it, it'll then actually be signed off by both the tenant, the actual landlord, and if there are personal guarantees, they'll be provided and signed off on by those personal guarantors for the lease. So we provide advice to clients, like outlining what their legal obligations are and what they need to ensure they undertake prior to actually having the property taken over and taking up occupation of it. And so that'll include things such as arranging the proper insurances, getting the signed lease all signed by all parties and returned, and also making sure the deposit has been paid, and if there is a bank guarantee that's needed to be issued, that's been arranged and exchanged. It's then important, once we've actually got this lease in place, to diarise the important dates. So those dates will be when the actual lease expires, and often leases will include an option period for renewal. So if there is an option period for renewal, there's generally a time frame that needs to be done within. So generally it might be within 3 to 6 months prior to the expiry date that the tenant has to let the landlord know if they wish to take up the option to renew the lease. So you want to diarise those dates so you don't miss it, because from a tenant's point of view, if they do miss that date, then they could basically give up their right to take up that option period. The last step is essentially ensuring that the lease is registered on title to provide indefeasibility if it is for longer than 3 years, which I'll go into that in a bit more detail later. So what actually is a lease then? So a lease is essentially a legally binding contract that gives the lessee certain rights to a property for a set term. So you should never be signing a lease without understanding all of its terms and conditions, because like I said, each one is very different. They're not a standard document, unless of course it's a shorter commercial lease where it may be an REQ tenancy agreement that's entered into. If you are unaware what you're agreeing to, you may experience serious financial and legal problems, which is why you want to make sure that you are properly understanding the terms and seeking advice from your solicitor prior to actually signing off on that lease document. In terms of negotiating the agreement for lease, there's certain things that you should be aware of. An agreement for lease is actually not a binding document. So it's setting out the main terms that will make up the lease, but it is not binding. Often with the agreement for lease, so it may include terms such as if the landlord solicitor has drafted the lease and then the lessee decides not to proceed with it, that the lessee has to still pay the landlord solicitor's cost for drafting that lease, because the intention was there essentially to have it drafted and they've had to pay that cost. So it is only fair then that gets passed on to the lessee. It's important that you do have the correct entity in place when entering into the agreement for lease. So often, sometimes the tenant will want to have a separate structure set up. They don't want to be entering into it in their personal names for various reasons. And it's important that structure's put in place and it's listed on the agreement for lease, because like I said, that is going to be what makes up the terms then of the actual lease agreement. Now, it's important that we're actually negotiating and determining the key terms of the lease at this lease agreement stage, because once that's been agreed to, it's very hard to then go back and negate those terms and try and renegotiate something else once the draft lease has already been drafted. So things such as the price for the rent that you're going to pay for the premises, what security bond amount that you want to put forward, whether there are personal guarantees, the deposit, which is generally 1 month's rent in advance, the term of the lease, when it's going to commence, all those things need to be negotiated at the outset to form the agreement for lease. There's no point, agreeing to that in the outset and then, when it comes to draft lease stage, trying to renegotiate something completely different. As I mentioned before, we want to undertake the appropriate legal searches involved in leasing matters. So the title search is going to reveal to us who actually owns the lease premises and the actual, what we call the legal description of the property in terms of the lot, plan and title reference. We want to make sure that all aligns with the lease, because that's what essentially we're signing up for. The company ASIC searches, so we want to see who the director's secretary of the company is and the ACN. And again, we want to make sure that that's accurately reflected on the lease and that we're getting the correct signatories for that company. So if the company does have more than 2 directors, we only do need 2 directors to sign a lease under the Section 127 of the Corporations Act. But if there is more than one, we do need to make sure we've at least got 2 people signing. We can do a body corporate records search, which will give information about the scheme. That's up to the actual tenant themselves. If they're wanting more information on the body corporate, they may be able to request that information from the landlord or the agent involved to get a bit more information regarding the body corporate records if needed. Some of the clauses to be aware of in retail and commercial leasing. So there's obviously, a vast amount of clauses that will be included. Some of the leases we draft and we review, there's sometimes 60, 70 pages worth of terms, but some of the most important pertinent ones, which we'll go through today, number one, obviously being the actual rental consideration. So the amount that the lessee is actually paying to occupy those premises. So generally it'll be an amount plus GST. It'll generally be based on a per annum term, and then obviously there will be increases over the period. So generally leases will increase by a fixed amount. So for example, it may be a 4%, 5% fixed increase, or it could be CPI, or sometimes we draft it or we see it where it's higher, either of those, whichever one is higher, CPI or the fixed increase. Often if there is an option to renew the lease, there will be a market review as well. So if the lease is for 3 years, and then there's an option period for a further 3 years. At the end of that first term, the first 3 years, it will then be reviewed based on what the market rent is at that time. The next important term that we have is what's called the security deposit. So security deposit is essentially basically a deposit being put forward by the tenant so that the landlord can be assured that the tenant is going to make payments when due and payable, and if they don't, or they're in breach of any of the terms of the lease, then the landlord can call upon that deposit to recover some of the loss that they've experienced. Generally, a security deposit may be anywhere from 3 to 6 months worth of rent, and that security deposit can be paid in various different ways. Often there's obviously the main one is the cash deposit, but sometimes often the tenants will want to actually pay that by way of an actual bank guarantee. So they've got those two options there generally. Obviously another important term is the actual term itself of the lease. So how long is the lease going to go for? So when will it actually start? When will it expire? And as I mentioned before, is it going to have any option periods? So if it's simply just a term, one term, for example, 3 years, at the end of that term, the landlord is under no obligation to renew that lease. Often it is a good idea for a tenant's point of view to have the option periods included. Times tenants can expend quite a lot of money, fitting out premises. So if it's only for a small term to begin with, they want to have that option to renew. Should business be going well and they're still happy with the location, to then keep going with the lease. Now, when a property is only part of a property, as in it's, it might be a set of shops or whatever, and they're taking up occupation of one part of the premises. So example, it's one lot, but it's a strata. The term of the lease, it cannot be more than 10 years without having council approval, because it's basically considered like a subdivision. So the term of the lease can't be more than 10 years in those situations, and that includes the option periods. So that's important to know, because if you aren't leasing, entire property, so one whole lot, then it must be less than 10 years unless development approval is sought for the, rezoning of it all. Now a fit out. So often, as I mentioned before, a tenant will take up occupation of premises, and it's not, the building and structure is not what they need or require for their business. So there's going to need to be a fit out undertaken. Now, who's actually, responsible for that fit out and the defects and the wear and tear to it? So if a tenant's taking over and the fit out's already there, they're happy with what's there, then obviously they're responsible for any negligence, caused to that fit out. So example, if they've, ripped holes in carpet or, they put holes in walls and things like that, they'll need to repair them. Simple fair wear and tear though, that does come down to the landlord to make sure, that fair wear and tear is seen and carried out, and things of like that's capital nature works is also up to the landlord to make sure that they're funding those things. The other thing, which I could probably already mentioned now, is the actual renewal options, which we've gone through. Like I said, we can have options to renew, which we spoke about before. Another important term of the lease is actual permitted use. So with a lease, it can be used obviously for multiple different purposes, depending on the business that's going into those premises. A common one obviously is professional services is generally just an office, but other places it will be a retail store, or it might be an allied health clinic or whatever it needs to be. It will stipulate that in the lease. need to make sure as the tenant that that does adequately, cover off what they intend to do in that business, because essentially the lease is limited to that. Now, permitted use can't be obviously for anything illegal. It can only be for legal purposes, and it's up to the actual tenant to ensure that that complies. They've got any council approvals and things that they need to carry on that type of business in those lease premises. One of the other lease terms to be aware of is the actual outgoings. So outgoings, depending on how the lease is termed. So sometimes with leases, you'll have like a gross lease, meaning that basically everything is included in the rent and there's no outgoings payable on top of that. Otherwise, you will have rent plus outgoings that is payable that you need to budget for. So you need to be aware what the outgoing, the estimate of outgoings are, and outgoings will include or can include things such as paying for the rates, land tax, body corporate levies, insurance that the landlord has over the property. Basically, all those types of things can make up the outgoings cost. Any maintenance and cleaning fees and things like that. So it can end up being a big expense on top of rent. So it is important to understand what that estimate is at the outset. Assignment and subleasing is another important term of the actual lease, because it gives the tenant the ability to assign, which means basically just transfer their rights under the lease to a new tenant. So for whatever reason, they outgrow the premises, they no longer wish to carry on their business, they essentially then can assign the lease. So basically the terms remain the same, but essentially just someone else taking over that lease. Subleasing, a little bit different. That may mean that, you've got a big lease premises, 500 square meters, but for whatever reason, maybe you're downsizing in business or something like that, you no longer need all of it, or, at the outset you thought you would and you thought you were going to grow and you didn't, and then you might want to sublease, half of that space or a quarter of it out to someone else. Often the landlord will require details, whether it be for an assignment or sublease, of who the incoming assignee or subtenant will be, and they'll need to provide consent before that can go ahead. But we need to make sure that those two terms are included in the lease to actually allow for that at the outset. Now, maintenance and repairs, that is a big one. Obviously, we need to know who is responsible for maintaining the actual lease premises. As I mentioned briefly before, for general fair wear and tear, it is up to the landlord to repair those things and things of a capital nature. But other things like broken light bulbs or smashed glass and things like that, that will come down to the tenant to repair and maintain those things. Air conditioning is another big one. Different properties have different air conditioning systems in them. Often, it depends on the lease, but often sometimes tenants will be responsible for undertaking, regular maintenance of the air conditioning equipment. So the lease may stipulate that every 6 months or 12 months that they need to have a proper air conditioning technician come out and service that air conditioner. If aircon is something that the landlord's responsible for, again, that could be then passed on as a outgoing fee that the tenant will have to pay for eventually as well. So what actually happens if the lease premises become damaged? So obviously, this can happen, a lot of the time where tenants taken over premises and all of a sudden they've become damaged, by different means. Unless it's otherwise been agreed, lessees usually have an obligation to maintain the premises in good repair, as we mentioned before. So this includes damage could be done from, various things, like I said, but obviously fires, floods, lightning storms, natural disasters, these things all happen as well. The obligations will extend to cleaning out the premises and actually repairing or replacing any fixtures and fittings. And you'll also have the responsibility of returning the premises to the same condition it was prior to the damages. So with repairing structural damage to a building, however, that's usually the lessor's responsibility, depending on the extent of the repairs needed. So if any damage occurs, you should first speak to your solicitor and insurer to clarify the best course of action, as every case is very different depending on the lease terms. It's always advisable to speak to your insurer to identify if your general insurance is actually going to cover the business property, and in the consideration of the probabilities of natural disaster damage in Queensland, it's also recommended to explicitly discuss a force majeure clause and, the definition of that being included in the actual lease. So a force majeure clause essentially is to deal with, natural disasters. So now you know, like I said, we're talking about retail and commercial leases. It's important to be aware, though, that retail leases in Queensland do have further stipulations, and there's a whole separate set of legislation that basically covers off on retail leases in Queensland. With retail leases, there is additional requirements in terms of disclosure. So there's an actual lessor disclosure statement which must be given over to the lessee at least 7 days prior to them actually signing the lease. So the lessee disclosure statement as well is another document that needs to be given, and that has to be provided to the lessor at least 7 days before the start date of the lease. As part of the retail leases, there's also a legal advice report, which has to be completed by an Australian lawyer under the legislation. And there also needs to be a financial advice report provided by the tenant's accountant. Again, that's needed before the lease is actually signed off on, to say they've got these advice from their lawyer, their accountant, and they understand the terms of the lease, and they, you know, think that they can fulfill the obligations in terms of rental payments and the increases that will come along with them. Now, as I mentioned before, we need to make sure that all parties to the lease are actually signing them correctly. So Section 127 of the Corporation Act will apply if the parties to the lease are actual companies. Now, if you are signing as a company, there is no witness needed. So although the standard Form 7 lease, you know, a titles office form that we use, you know, it does have a witnessing section. If it is being signed on behalf of the company, they don't need to complete that. However, if the tenant or the actual landlord are an individual, then they will require a qualified witness, and a qualified witness will be either a solicitor, a justice of the peace, or commissioner of declarations to witness their signature. Leases will need to be printed single-sided if they're being registered with the titles office, as they otherwise won't accept them for registration. Often we'll get leases signed in triplicate. So essentially what will end up happening is the lessee will have a copy, the lessor will be able to keep an original copy, and the third copy will be the one that's lodged with the actual titles office. So the legal obligations to actually occupy the lease premises. So as I mentioned before, we obviously need to make sure as a tenant that they're complying with the permitted use that's been stipulated in the lease. All documents, all the lease documents need to be signed and returned. So there's various different documents that can make up a lease. So sometimes obviously the main document will be the actual lease, but as I mentioned before, if it is a retail lease, you'll have all those other 4 documents mentioned. Depending on what the situation is, if there is incentives being provided, sometimes there's a separate incentive deed, sometimes there may be a separate car park license agreement as well. And sometimes there's even, you know, another document just like outlining general terms of the building rules and things like that will be signed off on. The other thing that will be needed before handover of the lease premises will be that the tenant needs to make sure that the security bond is paid, or that the original bank guaranteed has been issued to the landlord and they're satisfied with it. And obviously the insurance certificates will need to be provided as well to the lessor. Generally with those insurance certificates, it will be a requirement under the lease that they also list the lessor as an interested party. So, you know, if something goes wrong, the lessor needs to make a claim, they can do so under the tenant's insurance. As I mentioned before, we want to be diarising the key dates once we've got the fully signed lease. So the market review date, as I mentioned, if there is an option period, this will generally be at the commencement date of that option period. If there is any annual increases, either by CPI, fixed amount, or sometimes it's based on, you know, the turnover that the business is actually making. So for example, there's generally like with retail leases, obviously the turnover, it's basically known as turnover rent. So essentially the tenant will pay rent plus a percentage of their sales, which is known as a turnover rent. Now, the other thing to diarise as well is the date to take up the option period. So as I mentioned at the start, generally it's 3 to 6 months prior to the expiry date, but that changes on, you know, depending on what each lease says. But we obviously want to make sure that that date is diarised so it doesn't get missed. And if the tenant does choose to take up the option period, they've done so within the required time frame. And obviously, you know, one of the most important ones is the expiry date. You know, you need to know when that lease is actually coming to an end, and obviously most leases will include make good conditions, meaning that you've got to bring the lease back to the condition it was when you entered into the lease. So this often includes, if you were taking over a bare shell, you bring it back to that. So any fit out that you've put in, will need to be, ripped up and, bring it back to make good conditions. So, you might have to apply 2-3 paints of coat and, cleaning carpets and things like that. So in terms of registering the lease with the titles office and why we want to do this, so if a lease is for longer than 3 years, you don't automatically get indefeasible title. If it's for less than 3 years, then you certainly it's just an automatically rule that you get indefeasible title. What indefeasible title means that if the property was to be sold to another owner, who would then basically become the landlord, they don't need to recognise that lease if it is not considered indefeasible. So if it was for longer than 3 years and not registered, they basically, the lease could be terminated by that incoming owner. So with REIQ commercial tenancy agreements, they cannot be registered, but as I mentioned at the start, they can only be for a period of 3 years or less. So we don't really need to have them registered anyway, because we're automatically getting that indefeasible title. Now, in terms of registering the leases, in Queensland, Titles Office are the government organisation who is the holder, and we register documents with them, and they charge fees. So basically it's $224.32 to register the lease, or otherwise it's $266.45, including the actual sketch plan. So a sketch plan will be included if a lease is not for an entire premises. So like I mentioned, an entire premises will just be, one lot on a particular plan. Whereas if you're only leasing part of a lot, like I said, if it's a strip of shops and, it's all on one title and you're leasing, shop one, that's when a lease sketch plan would be needed to identify that particular area that you're leasing. Any option period should also be registered with the titles office, and that should be done by what's called a Form 13 amendment to lease. If you decide that you're going to take up the option period, we want to make sure that that's document signed off by both parties and then also registered on the title to note that. That's what I just went through, sorry. So the lease incentives. So what is an actual lease incentive? So essentially it's a bonus that's offered to a potential lessee to motivate them to enter into the lease. So often lessors will have to provide this so that they can get someone in the premises and get it tenanted. And so they'll be basically providing a discount. The lessee feels they're getting a benefit from what they will not get from any other lease proposal, and that greatly influence them to actually enter into the lease. So lease incentives do not just take the form of discounts though. So there's various different types of incentives that can be given. So it can be obviously a rent-free period. So they could be getting, 3 to 6 months rent-free for the start of the lease. Sometimes it can be done on a percentage. So it might be 50% for the first 6 months. Otherwise, it can be done as an actual rent reduction. The rent reduction is what I just talked about. The actual contribution to the fit out. So like I said, fit outs can be expensive. Some lessees could be spending, $200,000, $500,000, whatever it is on their fit out, and the lessor could contribute to that. So they might, sometimes they're contributing to the whole fit out or a percentage of that. They might, put in $100,000 towards the fit out, whatever it is that's been agreed. But they're the 3 most common types of incentives that we see that are offered. As I mentioned before, they can be documented in a separate incentive deed. The reason for doing this is the lease, when it is registered on title, all the terms of the lease are then made publicly available, because anyone can search the register, pay a fee to get to download a copy of that lease. Now, having the terms of the incentive in a separate deed means that not everyone knows what it is. A new tenant that's coming on board, once that lease expires, they don't know what the previous tenant was offered by way of discounts from the landlord. The premises next door, again, the tenant that's looking, then they can't just search and find out, what type of discount was given. So it's really, protects confidentiality from the landlord's point of view, so that not everyone knows what discounts were given. How are lease incentives actually enforced? So that's what I said is, the incentive deed and the reasons why you would have it in a deed as opposed to actually actually in the lease. It still needs to match up with each other, so it still needs to, be linked to the lease in terms of, still needs to make sure that we're talking about the actual lease and the lot and plan and, when that lease commences and will expire, so that we know that it's still in regards to that particular lease. We'll also outline the circumstances and how the deed may be terminated, and generally that's if the tenant was in breach of the lease, then the deed would be considered terminated as well. There are concerns though with lease incentives in terms of the rent reduction. So any rent reduction will not be considered when undertaking a rent review. So if, like I said, the option period's taken up and, market review is taking place, they're not going to be giving, another incentive at that point in time. The incentives are generally given at the start unless it's stipulated that they're to be carried out, over various years of the lease. For fit outs, the minimum requirements lessees must meet. So generally, if it's a incentive towards the fit out, tenants may be required by the landlord to use certain contractors, making sure they've got certain insurances and things in place before the landlord will just hand over that money. They'll need to provide receipts to reconcile that they've actually paid the money before the landlord will just give them that incentive. But as I mentioned before, if there is a breach of the lease, then the incentive is basically considered null and void, and the tenant would have to, repay that incentive plus, whatever other breach they've been involved in the lease. That's kind of the main things I wanted to talk about in terms of retail commercial leases. I know it's probably a lot of information and lots to think about, but there is a lot involved in retail and commercial leasing. I think it's important to be aware that there is a whole separate piece of legislation, the Retail Leasing Act, that applies to retail leases, and extra stipulations and documents that need to be provided when we are entering into those retail leases. I probably should say as well, in terms of how we know if it is a retail lease or not, basically leases that are excluded from being a retail lease are retail shops with a floor space of more than 100,000 square metres. They're not considered a retail lease. And the Act also won't apply to any leases for non-retail businesses that are operating in like a multi-level building where only 25% or less of the total lettable area is used for retail purposes. Feel free to get in touch with us. Happy to have an obligation-free consultation with you to discuss your leasing matters further. But otherwise, do appreciate you coming along today, and hopefully you've learned a few things. Thank you for tuning in to another episode of Property Power Talks. We hope you found today's insights valuable and engaging. If you enjoyed the show, don't forget to subscribe and leave us a review. For more information or to connect with our expert team at MB Property Law, then please visit our website at noborderslawgroup.com.au. We look forward to having you join us next time for more expert advice and actionable strategies to master the world of property law. Until then, stay informed and stay empowered.